petition is by Justice Odero, my lord.
And my lord, to respond to what my senior Council Ngoya raised about them being allowed to produce that certificate now.
Yes.
The meaning of the word accompany is ordinarily that those two must be brought at the same time, concurrently. And my lord, the issue here is not even mostly about that certificate. It is also about the accuracy and veracity of those videos, because we do not have the source of the videos. We do not have anybody we can cross-examine on the occurrences of those videos. For all we know, they could be AI generated. They could be deepfakes. The internet has advanced recently, my lord, and it's possible to do those things. There is no affidavit that is accompanying those videos. Therefore, there's no person we can put on the stand and cross-examine on the veracity and accuracy of those videos.
Let me give my short ruling to that. Counsel for the petitioner has conceded that the playing of the videos today would allow comment and observation by the parties. I agree with Counsel Kirimi in that regard, that it would blur the distinction between hearing and highlighting of written submissions. Counsel Mukele and Counsel Mwaria have, on the limb of objection on electronic certificates, have stated this is canvassed in their respective written submissions. Consequently, 1, the videos shall not be played today at highlighting, and the court shall view the videos through the stated links that are given in the petitioner's affidavits and certificates of production of electronic evidence. 2, the question of certificates shall be canvassed in the judgment as the certificates have been produced and we are past the hearing stage, and there is no question being raised to authenticity substantively. The objections are in the opposing parties' written submissions. If the objections in the submission succeed, the court shall determine as much and not rely on videos. Parties are reminded that in addition to producing evidence, there is material in the public realm on this issue. That's 21st February 2025. I've read the affidavits and I've read the written submissions. I understand, and I'm sure the opposing parties understand the direction that the videos being played today will have gone. The challenge is, if you're opposing something that is already in the public realm, it's canvassed on news reports, the judge may say, that's fine, I strike out the videos, but the judge cannot erase what the judge read in newspapers or saw on television. So that issue was dealt with, unless someone wants to raise another objection.
My lord, not another objection, but in your ruling that you've just given, you have said that no objection has been raised to the authenticity.
You cannot say authenticity is we do not know. You cannot prove, you cannot assert a negative. You have to say this is AI generated because we ran it through software and it said this is AI generated content. We have very many publicly available software. It cannot be enough for you to say I don't know if it is authentic, therefore it should not be submitted.
We are guided, my lord, but we hope our objection has been registered on the side.
Counsel. Counsel, please rise. Please rise. Counsel, which video is inauthentic? So that I record which video is.
Your lordship, we contend that all of them are inauthentic.
Why?
Because we cannot test the veracity of those videos.
If you cannot test the veracity of the videos on the 21st of February for documents that were filed well back, what is the court supposed to do, counsel? You should have taken these links, you should have tested them, run them freely available. You cannot say you want to reserve something that you cannot prove.
Your lordship, it's a law that a party that makes a certain assertion should prove it. It's the duty of the petitioner.
Prove your assertion that this could be AI generated.
And it is also the duty of the petitioner to provide reliable and authentic evidence.
You cannot say that something is inauthentic because you have not confirmed whether or not it is authentic. The certificate is supposed to give you the opportunity to then dispel the contentions that are being made. I will not record a reservation because I cannot see a reservation.
Your Lordship, I think we're in agreement, me and you. It's just because we are in agreement because our issue is that this certificate was filed on 19th of February, way after we had filed our submissions.
Let me give my view on that. My view has always been, even in private practice as a practitioner, you should object to something when it is being produced as an exhibit, not even marked for identification, when it is then being produced as an exhibit. Because the party may elect never to produce it, so it would not be an exhibit. In civil trials, particularly in the way we have canvassed this petition, the moment we went beyond here, then whatever is on record is on record. Sadly, highlighting of written submissions is not the time to change. So the videos will not be played. I will access the links. If there's a link that is not working, as has been stated by one of the council opposing, then, and please don't change the links because you can't change the links. And I'm savvy enough to see if I look at the upload date, and the upload date is different. If the upload date is after the filing of this certificate, then we have a very, very big problem. So please don't